Welcome, everyone, and thank you for attending Hawthorn University's webinar series. I'm Paula Bartholomew, the Director of Online Events, and I'm always pleased to be able to be here together with you and able to facilitate these presentations. I'll remind you that we'll save time for our question and answer period at the end of this presentation, and we'll certainly respond to any of your questions or your comments at that time, but I encourage you to write them into the question panel at any time. I'm paying attention to them. I'll take care of you. I'll respond if I need to, and we'll have you in queue for question and answer panel at that time. And I expect that we're going to have some terrific information here today. Therefore, this presentation is being recorded and it'll be available for replay on our website in just a few days. All right, and so because the fact that awareness of nutrition and health supportive practices are growing, we're really fortunate to have Lisa Fraley return to Hawthorn to inform us about the legal ramifications of online marketing. Lisa's going to address what's needed to know to reduce your risk when it comes to marketing online or working with clients outside of your state. You'll learn how to identify your state laws, how to apply 6 specific legal steps to lower your risk, and outline 5 legal documents that can help limit your liabilities so that you can make conscious choices as to the type of offers you want to make to your clients in the online space. You know, I really feel this presentation is essential, and it provides information and resources that are so needed for us and will just be added to our professional toolkits for sure. Those of you that have not had the fortune of being introduced or knowing Lisa Fraley yet, let me tell you a little bit about her. She's an attorney, a legal coach, a speaker, and is the #1 best-selling author of Easy Legal Steps That Are Also Good for Your Soul. She's also the host of Legally Enlightened podcast on iTunes. I listen to it frequently. It's fantastic. She's a frequent legal expert on hundreds of webinars and podcasts, taking stage alongside many of today's thought leaders. Lisa's mission is to help small business owners understand that the law can be accessible, empowering, loving, and even spiritual. And as a holistic coach and life coach, Lisa blends her legal expertise and training to help thousands of heart-centered entrepreneurs protect their businesses and brands with contracts, disclaimers, trademarks, and more. She shares her legal love through do-it-yourself legal templates, online courses, one-to-one services, and she's known for aligning legal steps with the chakras. So join the Legal Love tribe, and you can also receive some free legal tips at our website at lisafraley.com. All right, all that said, it's a pleasure to have you with us again, Lisa.
Thank you, Paula, so much for having me. I'm happy to be back, and I'm so grateful that you asked me to share about this particular topic because it does come up so often for so many health practitioners and holistic health, coaches, etc. The
Yes.
legal ramifications of online marketing. And so thank you for inviting me, and I'm thrilled to share this with you all.
Excellent. I'm going to let you take it from here.
Wonderful. So part of the reason why I think Paula asked for me to share this with you is because it does become very important to be able to talk about online marketing. We know that this comes up so often. And so when we talk today about online marketing, what are we talking about specifically? And I just want to share that we're going to focus on 2 specific areas. First is, what is online marketing? This will be paid courses, programs, and products that clients can view, participate, or download, and also those delivered online through a platform or service that reach many, many people. So these are things that we think about a lot when we're delivering a group program or an online course or a downloadable product or service where you have clients actually paying for them. That's programmatic course that you're providing, but it also can be marketing as well. And the second area that people ask about a lot are the types of things that we do to really generate interest with clients. So free e-newsletters and webinars and information that's really delivered electronically through a platform or on demand, like a webinar or a podcast or something like that. And it's usually used to attract your ideal clients. So we're talking about paid work as well as free marketing information. So the area that comes up the most that I think so many people ask about is, well, what if I want to deliver these services, whether they're paid or even free, to people who are in my state, but what about people outside of my state? So let's talk for a minute about location, like where you are located versus where your clients might be located. So we know generally that you might want to work with clients in your state, right? You might want to do one-on-one health nutrition services. You might want to do that in person. You might want to get together and have several sessions face-to-face, or you might want to do that online through a course or a program or a product, by phone, by Zoom, by Skype, or even through some other online platform. That's for clients in your state. That's pretty straightforward. But where I think a lot of people get confused and wonder how it works is when you're trying to work with clients outside of your state, virtually, one-on-one, or online through a course, program, or product. So that's really what we're going to be focused on through a lot of this presentation today. So how do you know what you're allowed to do and what puts you at risk, right? So if you're a health practitioner and you're sitting in your own office at home and you're wondering, how in the world do I know what I'm allowed to do? I always like to say, just like the human body, when it comes to the law, there really is no one size fits all. Just like there's no one size fits all diet or eating plan for every person out there, there's no one size fits all legal approach either. So it's really important that you know your state law. And when I say your state law, I mean the state law where your business is based. So we're going to start by talking about where your business is based. Why is it important to know your state law? Well, there are several reasons that we're going to go through here. First of all, I know you all already know this from the teaching of Hawthorn University, but the first thing you want to do is not practice outside of your scope, right? But how do you often know what your scope of practice is based upon your area of expertise? Well, each state law spells out for you what you can't do and can't say. But here's the trick. Often it's spelled out, not so much what you can affirmatively do, but what you cannot do, because you don't want to infringe on what others can do in their defined scopes of practice that we'll talk about in a minute. Like you want to make sure you're not violating nutrition laws. You want to make sure you're not violating medical laws. And we're going to talk about that in just a bit here. But the first reason to know your state law is so that you don't practice outside of your scope. And the second is to know what you can call yourself. So some state laws have what we call title protection laws, which is just a fancy way of basically saying that certain titles like registered dietitian or certified nutritionist, or even the word dietitian or even the word nutritionist, you're not allowed to use those words unless you are licensed or certified or permitted by your state statute to do so. So it's important as you go out into the world and work with your clients that you're very clear not only about your scope of practice, but also what you can call yourself so you aren't treading on other people's territory without realizing it. So that's the second thing that I want you to be aware of. Third, and this is what a lot of our conversation will be focused on, is to learn how and if you work with clients one-on-one without putting yourself at risk. So as we dive into this a little deeper, I just want to share that all the information I'm sharing with you this evening is, or afternoon, based upon where you're located, or even morning, the next morning, based on where you're located, is really designed to be informational and educational, because each person's laws of your state or your province or your country are totally different. And I encourage you to work with a local attorney who understands your state law and the work that you're doing, the important work that you're doing. Now, I myself come from a background as a former healthcare attorney in a large corporate law firm. So I get the laws around licensed professions like nutrition and dietitians and medical doctors, chiropractors, nurses, etc. And I also went through my own training as a health coach through a certificate program several years ago, and also a life coach through a different program. So I understand the online space and the way of online services being delivered, online marketing being delivered as well. So working one-on-one with clients is really going to depend upon where you're located, and also, this is important, you all, how much you're comfortable with taking risks. So number 3 is to learn how and if you can work one-on-one with clients safely. Some states, like red and orange states, we're going to talk about in a second, have strict limitations around them. And number 4 is to determine your comfort level with risk. Now, I always like to say, I come to the table trying to share with you information that will minimize your risk and keep you as safe as possible, recognizing, as we all know, that the area of holistic nutrition is still very gray, right? The laws are a little gray. They're well defined around nutrition, well defined around the practice of medicine or the practice of other licensed professions, but they're not so clear when it comes to holistic practices related to health services. So part of this comes down to your own determination and comfort level with risk. Some people are more risk adverse. Some people are more prone to taking risks, and that's entirely personalized. So I want you to lean into this information this evening, recognizing that my job is to tell you what the law says as of right now, and your job is to determine your comfort level with taking risk and what feels good to you. Each person determines your own level of risk taking when working with one-on-one clients, groups, online courses, programs, or products, or informational products. Hopefully we're all on the same page about that, and that feels good to you. Okay, so let's start talking about some of these state laws in states that are a little bit more restrictive. You may have heard about state laws that have some limitations, that say that there's certain things that you can and can't do without being a registered dietitian or a licensed medical practitioner who's actually operating under that particular license. So for example, there are several states that you'll see at the bottom of the slide that have limitations around personalized or individualized nutrition counseling. That's sort of the catchphrase that you hear around the fact that these state laws are more restrictive around giving personalized or individualized nutrition advice. Some states, many states, this actually includes nutrition assessment, goal setting, counseling, or advice. And then some restrictive states even prevent you from doing group programs, courses, or nutrition education or information, like Ohio, my home state, which is one of the most restrictive states in the whole country. So when we're talking about restrictive laws, they really have the greatest restrictions around the one-on-one work with clients that's personalized or individualized. And so the states that actually have these laws are the states at the bottom. And this can change, you all. We'll talk coming up in a couple of minutes here about how you can find your state law specifically and what it says, and so that you can check back and watch to see if the law changes, because the laws do change. Some change you have to look on a quarterly basis often, sometimes even a semi-annually basis, but they do change. But those who are most restrictive are states like Ohio, Illinois, Florida, Georgia, Maryland, Minnesota, Tennessee, Kansas, Delaware, Iowa, Missouri, Montana, Nebraska, Wyoming, North and South Dakota, and Rhode Island. Now, there are a few others that you might want to check as well. This is where it gets really hard for us as holistic practitioners who believe in giving personalized advice and who believe in nutrition assessment and helping clients set individual goals and helping them plan personalized protocols or even just plans to help them. In these states, you want to be very careful about doing that, or recognize that if you do that, you do incur risk of being accused of practicing as a registered dietitian without a license, or practicing dietetics without a license. So I want you to just be aware of that and feel empowered in a moment about how to find your state law so you can read specifically what it says that you can and can't do. Each state is different. So even if some states are more restrictive, some might be even a little bit more lenient within this category of what we often call red or orange states. You may have heard that term thrown around. So that's the bad news. Now, the good news, though, is that you might be in a state that has more permissive nutrition laws. And if you're in a state with more permissive nutrition laws, that means that you still might be restricted in what you call yourself, right? Your title. You still might not be able to call yourself a registered dietitian unless you're a registered dietitian. Or you might not be able to call yourself even a dietitian or a certified nutritionist or even a nutritionist in those states. Those laws might still apply to you. However, In permissive states, you might be able to do personalized or individualized nutrition counseling. You might be able to provide nutrition assessment and goal setting, counseling and advice. And you might actually be able to provide nutrition education and information and courses and programs like group programs or downloadable information. But each state is different, so I can't emphasize enough that you still need to check your state laws, which we're going to talk about in a second. So some examples of these states that are permissive are New York, California, Washington, Oregon, Nevada, Colorado, Arizona, Utah, Texas, Virginia, North Carolina, etc. Now, it's very interesting to me that many of the permissive states are on the coast. If you look at the geographic distribution, not completely, because of course you have Colorado, Arizona, Utah, Texas in there. So it's sort of like the coast and the Wild West, and I say that with love. That kind of gives you a visual of where some of these more permissive states are located, but let's dive into how you can actually find out where your state law is. This is the part of the presentation where I want to empower you. I want to empower you to know how to find your state law. And the best way to do that are three different ways. First, you can look up your state law at holisticcounsel.com. This is a resource created for you by the Council of Holistic Practitioners, where you can go to this website and click on the Law and Policy tab and find your state law. Jonathan Posey, who runs this organization wonderfully, has summarized laws in plain English for you. Kind of like how I try to make the law more easy to understand. Jonathan tries to make the actual state laws more easy to understand and provide summaries of them. So you can go there and click on the Law and Policy tab and find your state. Likewise, you can also go to nutritionadvocacy.org and click on your state there. You'll notice on that homepage, there's a huge state map of all the United States. And this does apply only to the United States. Unfortunately, if you're in Canada or abroad, you'll want to talk to local resources to find your provincial laws or state laws. But you can go to the nutritionadvocacy.org website and find out the color of your state. What you'll see, though, there are states that are red and orange, which are the more restrictive states, and there are states that are green or yellow, which are the more permissive states. It's funny how they organize it like a stoplight, but it's a really good way to kind of remember. If you see red or orange, that's a sign you need to be cautious. And if you see yellow or green, that's a sign you need to use a little caution, but you mostly have a green light to go forward. So check out nutritionadvocacy.org, and you can click on the color of your state, and that will actually take you to the text of any existing state law or a proposed state law. And then finally, you can talk with a healthcare attorney, here's the key part, who understands holistic nutrition. Now, I used to be a healthcare attorney in a large corporate law firm, and this was many years ago where holistic nutrition wasn't as much at the forefront as it is now. But not all healthcare attorneys get holistic nutrition, which I'm sure won't surprise you, but some do. So you can find a healthcare attorney locally near you to help you navigate these laws, or if you need help, you can contact my team at clientlove@lisafraley.com, and we can try to point you in the right direction or try to help connect you to legal services near you if that's helpful to you. Again, please know these state laws change all the time, so check your state laws quarterly and then talk with an attorney about your specific situation so you can ask questions and get clear. But I hope that helps you have an overview of the lay of the land and just raise your awareness about how to be informed so that you can go forward working one-on-one with clients or working online with clients, recognizing you need to know your state law first. So let's look at that even a little more closely. A question I get all the time, as I've been alluding to, is what if my one-on-one client is actually located in another state or country? What do I do then? Well, let's address a three-step checklist that I've put together for you to kind of help you go through this every time to make sure that you are aware of how to best proceed. So number one, as we just discussed, is know your state law. That won't surprise you. We just spent a couple of minutes talking about that. If you're in a restrictive state, though, those red or orange states, you might want to stop here because you'll want to be aware of what limitations are upon you for working one-on-one with clients, whether they're in your state or outside of your state or country. If you're in a restrictive state, there's often limitations about working one-on-one, or you use your own degree of risk and go forward recognizing you could be putting yourself at a greater risk of investigation, the state investigating you, which has happened. That's not like a threat, like it actually happens. People do get investigated. It's not that you can't survive those investigations, but there are people who have had investigations and been charged with $17,000 fines, or who have been told they have to shut down their holistic health practice, or who have had to hire attorneys and defend themselves. So I don't want to scare you, but I do want you to be aware that this is real and that we are at the cutting edge. We are leading the way, but just to use some caution and be aware of what the laws say around working one-on-one with clients in another state or country, as well as locally. But if you're in a permissive state, if you're in those yellow or green states we talked about, then you can move to step 2. So number 1, step 1 is always know your state law. Step 2, I encourage you to use a written client agreement with your client, okay? Anytime you're working one-on-one with a client, I encourage you to use a written client agreement. Why is that? Well, because you spell out your client policies in writing. Why is that important? For many reasons, it's important, but one of the most important in this context is that you want to be using a client agreement that has a section called governing law. That's usually what it's called. It's a very standard section in client agreements, but it's called governing law. What does that mean? Well, it basically means that when you're in one state and a client's in another state, you know, whose law actually decides what will apply in your situation, right? You're in your state and the client's in the other state. So whose law has precedence? One of the things that you spell out in your client agreement is that your law, your state, the law of your state where your business is registered, is the law that will govern your relationship, your client relationship. That's why it's called a governing law. It's the law that will govern your relationship and any conflict that might arise in your relationship. We hope that you don't have any conflicts in your relationship with your clients, but if you do, we are basically saying in your contract that your client is agreeing now that the laws of your state will apply. So the written client agreement is important as your second step to not only spell out your client policies, but to make sure the governing law lists your state law as the law that will be followed if you're in a conflict and you have to turn to state law to help you. Okay, so that's step 2. And now we're going to move to step 3, which is to register your business locally. Now, this step is important for everyone, no matter where you're located. Why? Because you want to have proof in writing that your business is actually located in your state. So you will want to register your business at the local level to let people know, let the government know that you have an operational business. What does this entail? Well, typically it entails completing paperwork with your city government, sometimes your county government, sometimes also your state, if your name of your business is different than your personal name, your personal legal name, I should say. You want to complete some paperwork, and you usually have to pay a little fee to tell them that you're in business. This is so important on so many levels. First, so you have proof that your business is actually located in the state, so that you can include in the written client agreement we just talked about that the laws of your state apply, but also because you do want to be on record you have an operational business in that state, so you can pay your proper taxes and you can be on record and you can receive mail and have people know that you're a registered business in your community. Ethically, it's the right thing to do. Legally, it's the right thing to do. And you certainly don't want to be evading your taxes or not filing your proper paperwork with your government that's required for any business that operates there. So register your business locally. I do have a podcast called the Legally Enlightened Podcast, which is available on my website and on iTunes, where I have a whole podcast episode, 20 minutes or less, about registering your business. So you can take a look at that if that's helpful to you, if you'd like more information about that. But essentially, you're wanting to complete your paperwork and pay a fee at your city, county, and potentially the state level as well. So that's your 3-step checklist. know your state taxes, or state laws as to what you can do, have a written client agreement that spells out that the laws of your state are the ones that will apply, and then register your business locally so you have proof that your business is actually in that state. That will help you in knowing whose laws to follow. So hopefully you can see so far that as we've talked about your state laws and this 3-step checklist to help you kind of know what to do when your client's in a different location than you are, it's so critical to have these legal protections in place, both for practical reasons and energetic reasons. I'm sort of unique as a lawyer, as you might know if you've listened to my prior webinar, but I do like to help people understand how the law protects you in practical ways, but then also how it protects you energetically as well, and why that's even important. So in practical ways, as we've just talked about, the law and legal protections like contracts and agreements and things like that are there to help limit your liability and your exposure and your risk, to keep you safe, to keep you from getting into lawsuits, to keep you operating clearly with clear communication with your clients so you don't find yourself getting into legal situations. They also increase your professionalism, because whether it should or not, for whatever reason, people tend to take you more seriously when you use legal documents, because they see that you're taking your business more seriously when you use legal documents. It elevates your credibility in their eyes often when you are using legal documents. So there are a couple of practical reasons. The most important, of course, is to limit your liability and your risk to your business and your income and your livelihood. But beyond that, it's also does have the benefit of increasing your professionalism and raising your credibility. Again, I don't know that it should, but for whatever reason, it does. Beyond that, I personally believe there are energetic reasons why it's important as well. And the first thing is that it helps you to create strong boundaries. It helps you to shore up your boundaries. You know, those of us who are drawn to these helping professions where we really do want to help people live healthier, longer, happier lives, full of vivacious wellness, and long, happy lives, we tend to want to give a lot. We tend to be overgivers. We're people who want to serve. It's important to us to serve. It's aligned with our values to serve, but sometimes we can overserve. And so sometimes having legal documents in place can actually help you create some clear boundaries and policies around your client policies, around when you're available for communication, what happens if you have a dispute, what happens if someone misses a call or appointment with you. And it keeps you feeling more professional, but also being more professional, because you don't have a lot of gaps, or you don't have a lot of leaks around your money or your time or your energy. And that's sort of an unexpected side effect of the law. It raises your business vibe, I like to say. It helps you attract your ideal clients and really stand in different energy that allows you to feel more confident. Because when you have those legal documents backing you up in the practical ways, you feel more confident, you feel more secure, you feel more safe to really expand and share your services with the world. And that allows you to show up in a really professional, high vibe way that also attracts the clients you want to attract. And that's what we all want to do in our businesses. So there's 2 ways legal protections are important. Most lawyers just talk about the first reason, but I really feel strongly about the second reason as well. So to that end, what can happen if you don't have legal protections in place? Well, it won't surprise you to know that you'll have unclear policies and murky boundaries, like we were just discussing. You could be more exposed to liability if you don't have any legal documents in writing to fall back on, because you don't have any language stating your policies. And what's so fascinating to me about legal documents is that you would think, wouldn't you, that it's presumed that people can't come along and swipe your content, or copycats come try to take and claim your content and say that it's theirs. You would think it's obvious that if you created a program or an online course or a downloadable info product, that it's yours and that no one should take it. However, when it comes to the legal side, you actually, as the business owner and the health professional, have the obligation to actually put your policies in writing, to tell people how they can and can't use your content or your information, or your, to be aware of your disclaimers. That's your obligation. It's not presumed. So if someone comes to try to swipe your content or take or copy your program and put it into their program, you really do want to have that legal document backing you up so that you have language to fall back on, because it's not automatically presumed that they shouldn't do that. You have to prove you told them the parameters for how they can use your legal documents. So we don't like copycats. We don't like people swiping and copying other people's work, but you do want to have the legal document to back you there. And clearly, if you have a client agreement or written documents, you have fewer conflicts or headaches with your clients because you've already spelled out those client policies that we've been talking about. You've helped people to know what you expect of them, and that creates a smoother, happier relationship for you both. Some people say, hey, Lisa, if I give a client agreement or a written document, a contract to my client might just be terrified and run off and not want to work with me. They might be like, oh, I don't like legal documents. I don't want to sign this. This feels scary. This doesn't feel good to me. But what we found and what studies have shown actually is that clients actually feel safer because they know your policies in writing. They know where you stand. They follow your lead. They're looking to you to be the leader in the relationship. And they actually want to know what your policies are so that later, if they do have to miss a call or they do have to miss an appointment or they get behind on a payment, they already know what's going to happen. So you actually release some of their tension and anxiety at your initial stage of your relationship because they already know what your client policies are, and it allows everyone to relax. So it has the opposite effect of what some people might think. Having written legal documents also helps you not have to give refunds that you don't want to make, because you can have your refund policy spelled out in your documents. And if you find yourself in frequent legal situations, that might happen if you don't have legal documents that you're using. So these are just some of the things that can happen if you don't have legal protections in place. And of course, my role and my job and my heart is focused on trying to help you stay safe, help you feel confident, help you feel secure, help you feel empowered as a business owner and a health and wellness professional to help take care of people and increase their quality of life, but in a way that protects you and your income and your business, for sure. So how do you reduce your risk? Let's talk about some of the ways that Paula mentioned in the introduction, these ways to reduce your risk that you can actually put into place as soon as you wish. That we're going to go over 6 ways to reduce your risk. And the first, as I'm emphasizing and re-emphasizing, is of course, know and follow your state laws. So be clear about your state laws and know what you can and cannot legally do and use caution. Again, the amount of risk you wish to take is completely yours, but whatever choices you make in your business, just do it with awareness, do it with consciousness. Some health practitioners who come to me have, it makes you think of a little kid with their fingers in their ears going la 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 la, like they don't want to know what their laws are because they don't want to be told they can or can't do something. But that's not the best way to approach it, right? I would rather you be very aware of what your state laws are and you make conscious decisions about what you wish to do and not do in your practice and what risks you wish to take. I want to keep you safe. You want to keep yourself safe, but you also have the right to choose to do what you wish. So know and follow those state laws if that's a line for you, which hopefully it is. Number 2, avoid being charged with practicing medicine without a license. Now, this is so important because when you are a highly knowledgeable health or wellness practitioner, as each of you are going through Hawthorn University's programs, no matter which program you're in, you are being highly trained and educated, and you have a lot of knowledge and information. Plus, you may have your own life experience to draw on as well. And so it's very tempting sometimes to do some of the things we're going to go through here on this list, but please restrain yourself as much as possible. You are allowed to share information and education, but you are not wanting to tread into the practice of medicine that can really put you at risk for being charged with practicing medicine without a license. So the things that you want to stay away from and not do, because only licensed medical practitioners can do this, and as long as they're allowed in their scope of practice, you don't want to diagnose people, right? You don't want to diagnose illnesses or conditions when you're talking with your client or reviewing lab tests or having clients share symptoms with you that they're experiencing. Please refrain from diagnosing. You can say, from what you're sharing with me, it sounds like you might be experiencing some symptoms that could be associated with some specific medical conditions. I recommend that you speak with your doctor or go to your doctor or licensed health professional to find out if you might have a problem in these particular areas. Even if you yourself think you know what's wrong, please do not diagnose any medical condition. Although it can be tempting to want to do that, please don't. Second, you also probably know that you're not allowed to treat people or treat medical conditions. Yes, you may be offering an online program or working one-on-one with someone or a downloadable course, and you have information to share with them. That's great. You can share information, you can provide support, you can answer questions, you can help them learn about their situation, but you really aren't providing treatment plans or not allowed to provide treatment plans. You can provide protocols, but you don't want to substitute for or provide treatment plans that only a licensed medical practitioner can provide. So you don't also want to use any of these words either. You don't want to use the word treat in your marketing materials, in your online marketing materials. You want to stay away from that area altogether and leave that to the medical professionals. Third, and this word can be hard for some people because we also can't legally say that you can prevent something from happening by following your program. So a lot of people will say, but Lisa, I want to tell people that if they eat more leafy greens and drink more water and take certain supplements, that it can help, it can prevent them from getting cancer or have high blood pressure or heart disease or whatever. And the key is that you can't make a promise that it will prevent something. You could say that it might help prevent something or that it could help prevent something. And this will make sense to you when you think about the commercials that you see on TV. Like, for example, you know how we see commercials on television for, let's say, beauty creams or skin creams, particularly addressed towards women or people who identify as female. But those skin creams or eye creams, you'll notice will say things in the commercial like, this may help reduce the appearance of wrinkles. Which when you really listen to that, you're like, what? Help reduce the appearance of wrinkles? They're not allowed to make a medical claim that it will reduce wrinkles. Now you're going to notice that every time you watch TV and you watch a beauty commercial on television or in a magazine, they can't legally say that. And even Quaker Oats, I looked at a magazine yesterday when I was in the car traveling with my husband, and it was from Quaker Oats, and they called the Quaker Oats digestive do-gooders. There was a picture of the oats bottle and it said digestive do-gooder. Well, they're allowed to say that because they're not making a medical claim, but they cannot say eating more oats will reduce IBS or will eliminate IBS or will eliminate, you know, MRSA or whatever situations happening in SIBO. That's what I was trying to think of. They can't legally say that. So be very careful when you're saying something will prevent some other type of illness or disease, and just stay away from that word altogether. Likewise with cure. We aren't allowed to make a claim that a program that you're offering or a service that you're offering will cure someone of their particular ailment. Rather, I would like for you to focus on the fact that they could engage in their own self-healing process, their own self-healing journey. The idea that they heal themselves. You provide information and expertise and knowledge, but they heal themselves because you are not allowed to legally heal them. That leads into the last word here, heal, in that only doctors, licensed medical practitioners, and licensed clergy members are actually allowed to say that they can heal people because of our country's allowance and recognition of faith healing as a legitimately recognized form of healing. But the idea is that you as the practitioner do not heal people, they heal themselves of whatever their issue or ailment is. So I know I took some time going through this, but this area of practicing medicine is such a hot issue. And I want to make sure you're aware that you do not want to do these things or say that you do these things. Diagnose, treat, prevent, cure, or heal. Instead, use words like you educate, you provide information, you provide tools, you provide support, you provide coaching, you provide tools to help them in their own self-healing journey. Those things are all allowed, just not these medical terms. So that's the second way you can reduce your risk, is to stay in the clear with those words and those activities. Okay, let's move on to number 3. The third is you want to use caution, as we've talked about, in these restrictive states in particular, when using words that are most often associated with registered dietitians or sometimes even licensed nutritionists. And those are words like nutrition. which sounds kind of crazy, but in certain states, using the word nutrition on your website has been a trigger for investigations into coaches and health, the holistic health practitioners who are not licensed. States have come after people solely because they've used the word nutrition on their website in a restrictive state where they're not allowed to provide personalized or individualized nutrition. So be very careful of using the word nutrition. And I know it sounds crazy, but just use it with caution and be aware in some states that word can trigger investigations, which again sounds crazy, but I know of specific clients who that's happened to. So it's better to stay away from nutrition and words like meal plans, which are associated often with dietitians in traditional dietetics language, and move towards using words like sharing sample recipes or sharing sample meals or sample meal ideas, things that are a little bit more related to health information, not the practice of dietetics. So that's another way you can reduce your risk, is being very cautious of the words that you say when it comes to words associated with registered dietitians. Number 4 is to use disclaimers. Now, there's several different ways and instances in which you can use disclaimers. The first is written disclaimers. The second is verbal disclaimers. And third is the way that you're answering questions using disclaimers. So let's talk about each of these for a few minutes. First is a written disclaimer. Now, when you are operating in your practice, no matter where you're located, you do want to make sure that you're using disclaimer language. You'll want to have, there are a variety of different disclaimers that you would use. We're going to talk about one in just a minute, but specifically on your website, you want to have what I call a website disclaimer, which is a longer document that's accessible through the footer of your website. We're going to talk about it in just a second, so I don't want to go into too much depth right now, but this is actually a document accessible through the footer of the site. This isn't like the 3 sentences at the bottom of a website page. I call that a mini disclaimer. It's okay to put that in your website at the bottom of the page, but you really want a much longer 4 to 5 page website disclaimer that tells people even more in depth about what you're disclaiming your responsibility and where their responsibility begins. So for those of you who are like, what is even a disclaimer? A disclaimer is really legal language that helps to empower someone to know where your liability ends as the health practitioner and where their liability begins as the client. So you're essentially saying that you are certainly responsible for the quality of the content that you're sharing, but you're not responsible for how they apply it to their own lives, and you're not responsible for the results that they may or may not achieve, and you're not guaranteeing results. You are sharing and informing with them what you are responsible for and what they are essentially responsible for. So you do want to have written disclaimers everywhere. On your website, you can have one in your website footer, but you also need the longer website disclaimer. You want to put a little short disclaimer at the bottom of your program guides, accessible where people can see it every time you have a handout. You want to have a mini disclaimer at the bottom. Slides, video landing pages, opt-in gifts, everywhere in your practice, so that if someone were to pick up something that you wrote or you shared verbally or you shared as an audio or you shared as a video, you have a disclaimer written on any website page or any handout or any document associated with that. You also want to use verbal disclaimers in every video, podcast, audio interview. You might realize that shortly into this presentation, I paused and I shared with you that the information I was sharing today is informational and educational, but it's not personalized legal advice. I paused to tell you that as a part of the presentation, which was my verbal disclaimer to you. So that's an example of that. You'll also notice at the footer of this website, this is a really, really mini disclaimer just in the interest of space, but you'll see where I say this is legal information, not personalized legal advice. You have a responsibility and a duty to inform your audience with love and care and responsibility that you're sharing information, but it's not tailored specifically for them if they're just reading your website or listening to your audio interview, etc. So it can be done with love and care, but it is to empower people to know where your liability starts and stops. And then finally, when you answer questions from clients in a group setting, Like maybe you have a group program with a Facebook group and people pose questions in the Facebook group and you're answering them. Or maybe you have a weekly Q&A call where people can call in and answer questions, and you answer questions for people. One of the things you want to do in answering those questions is to make sure that you're sharing information with them, but you're also qualifying your answer by saying they need to check with their doctor or medical team. I know not everyone's going to love hearing that answer, but the reason for that, and I was just sharing this with a client today, the reason for that is because when someone's asking you that question in that Facebook group, or someone's posing a question to you on your group Q&A call, for example, it's quite likely that they're not sharing all of the facts about their situation with you, right? They might have medical conditions they're not disclosing, or medications they're taking they're not disclosing, or supplements they're taking they're not disclosing, or foods they're allergic to, or sensitivities they have. And if you just answered that question in a way that was definitive, you could be putting them in harm's way without realizing the totality of their situation. So you always want to qualify what you say with them making sure they're checking with their own medical team or doctor, out of a sense of ethical responsibility on your part, legal responsibility on your part, because you don't necessarily know all the facts of their situation, and this protects you and it protects them from being harmed by taking what you say and running with it. So answering questions from groups, you want to make sure you use a disclaimer, and it's also very clear that they need to know that you're not a doctor. They will listen to you with authority because you have this amazing education from Hawthorn University, and they will listen to you with authority based on your own experiences with your clients or your own personal experiences that you're sharing. And you will just want to make sure that they are, that they know that you're not providing medical advice as a licensed medical practitioner. So number 4 is to use disclaimers all over the place. Number 5, how else can you reduce your risk? Well, you can create an LLC or an S Corp to separate your business and your personal assets. This is a topic that we could go into for hours. However, just know that LLCs and S Corps are business entities that are created at the state level that are a company for your business. It's a formal company for your business. And the reason why people like to create LLCs, which stands for Limited Liability Company, or S Corp, which stands for an S Corporation, is to actually protect your assets, to protect your income, to protect what you own, your personal life. You might own your house and your cars, and maybe you have a vacation home or a boat or inheritance or insurance proceeds or whatever. You want to keep that separate from your business as your income grows, or if you already have a lot of personal assets already that you own. The idea is that when you separate your assets with an LLC or S Corp, you and your personal liability is separated from your business and your business's liability. What does that mean for you? It means that if someone tries to come after you or sue you or heaven forbid or file a claim against your business, generally speaking, your personal assets can't be touched. They can't come get your car or your house. Or if you're in a car accident that you're driving down the street on Saturday afternoon and you're heaven forbidden car accident, it generally means that someone couldn't get your business assets and come after your business receipts, your business income, your business bank account, your business savings account, etc. So LLCs and S Corps, people have a lot of questions around those. I do have some free podcast episodes you're welcome to listen to, like what is an S Corp? When do I need to have an LLC? You can check those out on my podcast as well in 20 minutes or less to help you there. So just know if you have questions, I'm happy to entertain some questions at the end about LLCs and S Corps, but this is one really good way to reduce your risk as a business owner and protect your money and protect your assets. And then finally, number 6, we talked about this a little bit, but you want to use legal documents with disclaimers, limitation of liability, and intellectual property clauses in them. There's 3 specific types of documents we're going to talk about in a second. One is a client agreement that you want to use for your one-on-one clients. 2 is your website disclaimer, terms and conditions, and privacy policy, which we'll talk about. And 3 is the terms of use, which you would use for your group programs, online courses, and info products. Now, just like the human body, one size legal document does not fit all. So you'll see here there's several different types of legal documents for specific reasons, but all of them will have or should have disclaimers in them, limitation of liability clauses, we call it, and intellectual property clauses in them. So we'll talk about that. Okay, so now that you have those 6 key ways to reduce your risk and your liability, let's talk about these legal documents I just mentioned so you can have a better sense of what they are and how they will help you in your business. So there's 5 key legal steps to limit your liability: website disclaimer, client agreement, website terms and conditions, website privacy policy, and website terms of use for online programs and products. And I'll tell you why they're in the colors in a moment. So the first document that I alluded to is a website disclaimer. This is the document that provides you with a base layer of website protection and really does create a lot of clarity for your website visitors to prevent any confusion. That's going to be accessible through the footer of your website. It's called a disclaimer because it disclaims your liability. And the reason why I put it in red is because I do energetically associate the website disclaimer with the root chakra. I align legal steps with the different chakras of the body because they protect you in different energetic ways. And this one provides you with some base protection to help you feel rooted and grounded and safe as you're launching your website to the world. So the first document you want to check on your own website is to make sure you have a website disclaimer accessible through the footer of your website for your base layer of website protection. Second, you want to use that written client agreement we talked about. The client agreement is what you use with one-on-one clients inside or outside of your state, provided you're in a state that's permissive and allows you to use one-on-one client agreements and work with one-on-one clients. This is what puts your client policies in writing, like we were chatting about. This is what you have the client sign and get consent to your policies. So they're in agreement with your policies. That's why it's called a client agreement. This document will include and should include limitation of liability and disclaimer sections so that when you are working with a one-on-one client who's hired you, they are agreeing through this written document already to know that you're limiting your liability. You're telling them where your liability begins and ends. You're telling them and disclaiming your liability and empowering them to know where their responsibility begins. And this helps to support your sacral chakra because your sacral chakra is associated with so many things, but is associated with income and abundance and money and boundaries and trust. And so this is the document that has your governing law section, that has your client policies, that has your disclaimer, that has your limitation of liability. It also has intellectual property language in it, which says that all of the content of your one-on-one program is yours and can't be taken or used by them. And you have them sign that document to really draw a nice boundary around your income and to build trust with your client by knowing all of your policies up front. So that's the client agreement that you use with your one-on-one clients. The next document is your website terms and conditions. Why do you want to have website terms and conditions? Because it honors your website content. What is website content? What do we mean when I say website content? Well, I mean the images and the actual text on your website, right? So it's when you pull up someone's homepage or about page or services page or blogs or whatever it is you have on your website, your opt-in page, your quizzes, things like that. That's your content. And this is the document that also is accessible through the footer of your website that says to people, hey, website visitor, I'm so glad that you're here. But by the way, you cannot take my website images or text and copy and paste it and put it in your website. That's your intellectual property. Those are your creative assets. And you help to ward off copycats with strong intellectual property language. And you help to plug boundary leaks and not let people come and take your work because you have language to fall back on to protect your website content. This document does many other things, but one of the main areas that I think is so important is to really protect your content and to have something to fall back on if someone does copy or swipe your work. So I like to say that the website terms and conditions supports your heart chakra because your website is your heart and soul of your brand. Your website also is what to help build trust with your website visitors and to share with them the heart of what you're doing. And so you really want to have a positive relationship with them with clear boundaries so that they're not going to, or that you have something to fall back on if they do come and copy your work without your permission. It's a horrible feeling. So you want to have a legal document to support you in place. The next document is also associated with the website, and that's the privacy policy. You probably heard a lot about the privacy policy last year when everyone was talking about GDPR, which is the General Data Protection Regulation that went into effect in the European Union and some other countries associated with Europe. But basically, this is the document that says that anyone who comes to your website and maybe they opt into your opt-in page with their name and email address, or they comment on your blog post, well, when they're sharing their name and email address, or they're commenting on your blog post, they're actually sharing personal information with you, their name and their email address. And I know that doesn't sound terribly private, but it is considered to be private, personally identifying information. So you do need to have a privacy policy that tells them how you'll keep that information safe and that you're not going to disclose it to people without their consent. This is what allows you to show respect and care for their information, and it supports the heart chakra as well by building that trust with your website visitor, because you have a clear policy, which is required actually by social media if you're doing social media ads, and is also required under GDPR laws, and is also just ethically appropriate to let people know how you're going to use their privacy, their private information. And you do that through your privacy policy. So that's the fourth document that you want to make sure you have. This one is on your website as well, visible through the footer of your website. And then finally, your terms of use for online programs and products. If you have a group program or an online course, or you are creating those downloadable info products like video courses or audio courses or a downloadable ebook or a recipe guide or something like that, this is the document that protects that content. So basically anything that's not one-on-one, any service or offering that you have that's not one-on-one. And this document is a long, hardy document that actually spells out how to protect your intellectual property. It says that all the content that you're receiving is my original content. It is owned by me, in other words, owned by you, and that other people can't come along and copy and take it. And if they do, here are the ramifications. Here's what happens, and here are the policies that they're violating if they take it. So this has more language typically than the client agreement, just because it's a longer document. People will come to your sales page or purchase your online program or group program. Sometimes they click a buy now button or enter their credit card information, and then they agree to your terms, usually using a little checkbox that you want them to agree to before they go enter their credit card information. This is how you spell out for them your intellectual property protections, your payment policies, your refund policy. It does include limitation of liability and disclaimer sections, because you do need to be super clear with them, with your programs, products, and services that are not one-on-one, how and where your liability starts and ends. And I do like to align this document with the throat chakra, because it's the document that you use when you're reaching one-to-many. You're reaching many people, spreading your message farther and wider through group programs, through online courses, through downloadable info products. And so I associate with the throat chakra as you're expanding your message farther and reaching more people. So with that, I hope that you've been able to sense and to know that it's my passion and my mission to really help you know what legal steps to take, easy legal steps that I align with the chakras one step at a time, because I don't want you to have to be worrying about lawsuits. I really want you to be able to focus on caring for your clients, sharing your gifts with the world, doing what you do best without taking that energy and worrying about the legal parts of your business. I want you to feel safe, secure, confident, and empowered, and really be able to just focus on caring for your clients. So with that, I will turn it over to Paula. I just want to thank you so much for your attention through that presentation, and I'm happy to answer any questions you have. And I've also included here on this page some resources for you around the do-it-yourself legal templates, the podcast, my book, if that's helpful to you. And you're also always welcome to schedule a free 20-minute legal chat to ask questions about your situation, where my team and I will try to help you or refer you to another attorney. So with that, Paula, thank you so much. And I'm happy to answer any questions anyone has.
Excellent. Thank you, Lisa. You nailed it.
I know that was a lot of information, but hopefully it was helpful.
Very helpful. I mean, you're succinct, you're concise, you're to the point, you're clear, and I I like
Thank
that
you.
very much. Right, right.
Thank you,
And
Paula.
yeah, and exactly what we needed here. You know, at Hawthorn, in our programs, we include a business course in each one, business relative to the type of program that they're in, and much of this is covered. And you went into things in such detail that it's really helpful to clarify a number of things.
Good. I'm so glad to hear that. That was the
Yeah,
goal.
yeah. Certainly. And, you know, one thing you emphasized is that state laws change. And yes,
Yes.
they do. They change regularly because of lobbyists
Yes.
and certain groups that are making proposals, making suggestions for laws that they would like to have in place or laws that they would like changed. So it is important to be mindful and to not just look at it once, but to see if anything has changed.
Yes,
And
absolutely.
yeah, and I'm so glad that you brought up Jonathan Posey because of the fantastic work that he's been doing
Yes.
with Council for Health Educators. And he has done a webinar for us in the past titled Grassroots Advocacy. I encourage anybody to pay attention to it, to look at it. It's in our archived webinars. He talks very much about the state laws and teaches us how to be part of the change, teaches us
Yes.
to be advocates for what we want here and not just let other people dictate it to us. Many situations we've had states where only the registered dietitians lobbyists are approaching the legislators and informing them of what they want and with their reasons. And it sounds all very logical and clear. And since there's no other perspective or point of view presented to them, that law gets passed. So that begs for us to be advocates for what we want. And I'll give one example. In California, several years ago, the registered dietitians came charging forward with just exact this situation, where they proposed a bill. And we're fortunate that there was a heads up about it. And the word flashed through the professional community, and Sacramento was stormed with holistic nutrition professionals
Wonderful.
presenting their point of view. The consequence was the legislators said, my goodness, we've never heard from you. This is the only perspective we've heard. It seemed reasoned to us. We're about to pass this, but we're going to reconsider everything here based on the flood of information that's coming in here. The upshot of that was that California passed a law that completely wiped out anything that the registered dietitians were proposing to restrict heavily only they could practice. SB 577 is titled the Freedom to Practice Act, which actually allows any unlicensed professional to practice in the state of California as long as we abide by a few simple guidelines. Some of which is that we fully disclose our scope of practice, our fees up front, our educational background, and many of the things that you're talking about here, Lisa. We have this law in place because we acted. And yet it's under threat again. You know, several years later, there's a law in front of the California legislature again. So heads up on that. There are one of the most restrictive laws in the country was in North Carolina.
Yes.
That law has been overturned, and now North Carolina went from a red state to a green state.
Yes.
Right? So these things matter, right? We've got to get out there and do it. So please look at that webinar, Jonathan Posey, Grassroots Advocacy on the Hawthorn webinars.
Wonderful. I'm so glad that you shared that because North Carolina is such a great example of how the law changed from that red to green because of the activism of the health professionals in the state and Jonathan's hard work and Laura, his colleague, and many others. But we are moving in the right direction in many states. And, you know, there is an important role of registered dietitians, I personally believe, in our world. And there's room for other holistic practitioners as well. It just shouldn't be exclusively only registered dietitians.
Exactly.
Anything that we all can do or you all can do to help keep the law progressing is so valued and appreciated by everyone.
Right. No way and did I mean to denigrate registered
Oh, of course
dietitians.
not.
They've got their
Mhm.
role. We teach respect here at Hawthorn for all
Yeah,
professions. We're part of a team. There are many
absolutely.
registered dietitians that are continuing their education at Hawthorn. Thank you very much. And there's a huge wave of within the registered dietitians moving towards more holism
That's
in their
right.
practices, right?
Yes, I have many clients the same way. So I like you, I have such respect for registered dietitians, and many are very open and interested in a more holistic approach. And then just like other professions, when there have been innovations, some others are more concerned or feel encroached upon. But in general, I do love the fact that there's so many registered dietitians who are so
Yeah,
open-minded. It's
right.
wonderful.
And we are an emerging profession as
Mhm.
holistic nutrition professionals. And so I think it's also part of our role to explain ourselves and what we do and what our training is. That, if you come out of Hawthorne with a master's degree or a doctorate in holistic nutrition, and you're talking to a registered dietitian with a bachelor's degree,
Mhm.
you have some clout. Um, and anybody that has shared their education, their resources, the tools and education that they get at Hawthorne, they're impressed with it. We can open doors by not being through, right?
Sadly, but yes, that's true. That's exactly right. That's exactly right.
So one of the questions that came in is about one of the first things you brought up was what to call yourself. And this comes up a lot because
Hmm.
title of one of our programs is Nutrition Consultant Training Program. Sounds just like, the clinical holistic
I know.
master's program. So what do so are you a holistic nutrition consultant when you come out of there? I think that's a very important piece that you put holistic before everything else, because it's nutritionist versus holistic, whatever you're going to call us, holistic nutritionist, holistic health coach, nutrition coach. There are a lot of options, but have you seen this, Lisa? Am I speaking
Yeah, yes,
competently here
you
about?
are. You are, Paula. Yes, and it always goes back again to what state that you are located in as a
Yes,
practitioner, because
right,
some states, the word nutrition doesn't, it's not on their radar as being something that bothers them. Having the word holistic in front of it is definitely helpful. But in some states, you could still include your degree, the name of your degree, on your about page or your bio or something like that.
right,
But you might choose to call yourself something other than the name of your degree if you are concerned, or if you're in a state where the word nutrition is flagged.
right,
So you have options. Just because your degree is in a certain with a certain name doesn't mean you have to call yourself that exact name. There
right,
are a lot of words in holistic wellness that are not regulated, right? Like you can use words like holistic coach, wellness coach, wellness consultant, holistic health consultant. Like there's many varieties. It's just
right,
words like nutrition and nutritionist and dietitian and registered dietitian, and sometimes
exactly,
nutritionists that are cautionary, based
right,
upon where people are located. And in other states, they don't care. You can call yourself whatever you want. So always, that's why
exactly.
I kept hitting home on it. Always goes back to know your state law, know your state law, know your state law.
Know
That
your
often.
laws and know what you're willing to risk. I'll give
That's right.
another example. I had a student a couple years ago that had gone through all of her courses, and towards the end of the program is the business course. In the middle of the business course is look up your state, know what your state laws are. Consequently, her jaw dropped and she burst into tears because
Mm-hmm.
it was Arkansas, and she's like, I've I've done this whole program and now I
Mm-hmm.
can't practice. I can't do what my goals and my intentions are. And we worked with her quite a bit to help her realize that yes, she can practice, that a number of other people are practicing there. And it's about knowing your risk and what you
Mm-hmm.
call yourself and what
Mm-hmm.
services you're
Mm-hmm.
putting out
That's
there.
right.
Your languaging and the information that you're sharing on languaging and keywords to avoid or to include are so helpful, Lisa.
Yeah, and a lot of people will say, well, this is crazy because it just comes down to semantics. Like, isn't it just about semantics? And
Hmm.
in some cases, it is semantics. And in other
Hmm.
cases, it's intention. In other cases, it's in actuality what services you are offering. So choice of language and your intention behind it is so important. to do, and that's why Paula, you recap so beautifully. Like when I talked about, it's always about know your state law, try to follow the law, and recognize that you can act with conscious risk. Like if you do risk, do it consciously. Don't put your head in the sand, know your state law, and act consciously. As a lawyer, I'm not legally allowed to tell anyone to violate the law, but I'm not actually. And I do always acknowledge that each person chooses their level of risk. And that's no different than when you're buying insurance policy, no different than when you're deciding where you live or where you practice. We all have different levels of risk, as, you know, for anything we do in our lives. So just do it with conscious awareness and choice. And then it keeps you in, I think, a more empowered state than if you just don't know. Like, please know, please be aware, and then just make your choices accordingly.
That's right. Beautiful. All right, so coming back, we have another question on state practices. So the question is it possible to set up your business in a state where you don't live, but where you work? For example,
okay,
she lives in Quebec, but works in Vermont. And so she wants to know, can I set up my business in Vermont?
Okay.
So,
sure.
Going on just a little bit here, she's a U.S. citizen and still pays U.S. taxes. Realize this is a very specific question, but
no, I
this,
understand.
you know, okay.
It could be helpful for people.
You know,
So first of all,
apply to those people who travel and work from, you know, someplace else.
Yes, yes. And so first, I just love Quebec. I love Canada. And Vermont is a fabulous state. So that's such a wonderful arrangement that you have. And so the answer to that question is that first, you want to make sure you're talking with an attorney in Canada as well. Second, you want to make sure that you're talking with an accountant in Canada as well, or whoever's helping you with your Canadian taxes and your US taxes. You might have an accountant in Canada. You might also have one in the US. I'm not sure how you do that, but be aware of the financial side as well. But the general rule is that you have to have a physical location for your business in the state in which you wish to register your business. And please know, for this specific example, I can only address American law. I'm not able to legally address Canadian law. So that's why you'll want to talk to an attorney in Quebec as well, in your province. But on the US side, anyone can register a business in a state where you have a physical location or a physical nexus, we call it, to that state. So you don't necessarily have to reside there, but you do have to have a physical location associated with that state. And you probably have heard of this before, because some businesses, not that I recommend this, because I generally speaking do not for small businesses, but some people register their business in Delaware and they live in like Idaho or something. It's not usually beneficial to do that as a small business, but some people do it. So there's no residency requirement, but it can impact your taxes. It can impact you financially. It can impact other things. So be sure to check with your local lawyer and then also your accountant to do that. But it is possible to set up a business in a different state, provided you have a physical connection to that state and it makes sense for you financially and legally.
Okay. And would she also need liability insurance in both places, Vermont and Quebec?
Okay, so liability insurance depends on a variety of different factors. There's lots of different kinds of liability insurance. So the first type of liability insurance that we all usually think about is what's called professional liability insurance. If you're a licensed medical practitioner, you would call that like malpractice insurance. But if you're a health or wellness consultant, you would call that professional liability insurance. And what that type of insurance does is protect you. And again, you have to read your policy and read the fine print and talk to your insurance agent. But basically, what it does is protect you with any type of service or work that you're doing within your professional capacity, within your scope of practice, within your professional work. So it's sort of service and product delivery based type of insurance. However, if you're someone who sees people physically one-on-one in an office in Vermont, let's say you have a beautiful office that you rent or a space that you rent, you might also need to have a renter's insurance or B general liability insurance. So if someone walks through the door of your office and trips over your lamp cord, then you are protected from what's called slip and fall insurance. Generally, if you have an online practice, you don't need to have slip and fall insurance because you don't have people coming into your space. You just need professional liability insurance, but it
Right.
always depends on the type of practice that people have.
Mhm.
And in that case, if your business is registered in Vermont, if your business is, you have a physical location in Vermont, your business is registered in Vermont, you're providing your services in Vermont, then you might only need physical or professional liability insurance in Vermont.
Mhm.
Not necessarily where you live if you're not providing services from where you
Right.
live. So it depends.
Okay. Terrific.
Great question.
It really was.
Thank you.
Mm. Coming back to state laws and the documents that are needed and legal approaches to working with clients, you were so clear on, the words, the specific words that we just have to avoid. Because we don't. We're not diagnosing and we shouldn't. We're not treating and we shouldn't. Not preventing. Well, I have issue with that one.
Well, you can
I'll relent,
technically prevent, but you could say sometimes that things have been, you can show studies that have proven that
Exactly.
something can prevent something. You could say that it might help prevent or could help prevent, but remember, we can't ever make a promise that something will
Exactly.
prevent something because, as I like to say, you're not standing there at midnight when they're opening the refrigerator eating a spoonful of ice cream and chocolate cake that's clogging their arteries. Like you can't promise that they're not going to get an illness. Like you just can't. So yeah, but to your point, I know.
Or that they will. So
right, exactly. We have no idea.
Right. It's just kind of a setup, though, isn't it?
I know.
But I think language there is important. And talking to somebody, it's like, well, the literature shows, the most recent research shows that. And so it's not you saying, here's the way forward, but literature shows this might be helpful.
Yes,
That's
and I
doable,
love the
right?
word might. I love the word could. And yes, and then it also is helpful if you actually have the studies to back that. If you've actually done the work to find the study to back that. But that's correct. You can cite other medical experts who do have the credentials to say that something could prevent or would prevent or might prevent, but you just can't do it yourself. Hence, Quaker Oats not being able to say, like that's why they call it a digestive do-gooder. Rather than this is like digestive protection against IBS, like they can't say that, and that's Quaker Oats, where there's a lot of research and studies that have shown oats.
Oh, they got the money. If they could have changed it,
yes,
if they could put that on there, they would have. You better
well,
believe
that's
it.
right, but they cannot, and I was very proud of them in the magazine for not doing that.
Good. All right. Well, circling back to. Maybe you can reiterate some here, Lisa, for recommendations, thoughts on working with clients in red states while your practice is in a yellow-green state.
Oh, sure. Okay, great example. So your practice is in a yellow or green state. So here are the things just to recap that you want to do. You already know, number one, your state law, you're in a yellow state, but be sure to go to those websites and please read the state law because not every yellow state is the same as every other yellow state. So do that. Number two, you want to use a written client agreement with your client who's in the red state, right? Don't forget, if you're doing one-on-one work, use the written client agreement. And in the written client agreement, your governing law section is going to have the name of your state, your yellow state in the governing law section. So that's the second thing. And then third, you do need to register your business in your yellow state to prove that your business is actually located there. So now what's happening, the reason why this is so important is because you're contractually agreeing with your client, and I shared this, but just to recap, you're contractually agreeing with your client that the state law that will apply if there's a conflict is your law. That client's basically giving up their right to follow their laws, and they're agreeing to your laws. Now, in our country, in the US and also in other Western countries, our society believes in the power of people to negotiate their own contracts so long as they're not illegal, unethical, fraudulent, you're not holding a gun to someone's head, it's not under duress. They allow the freedom of contracting so long as it's pretty fair to each side. And so you're allowed to privately negotiate whose law will apply. And that's why it's so important to follow those 3 steps. And you can put in your contract that your law will apply. So if there is any conflict, you're following your laws. And it says in writing, and they've already agreed to it up front. That's why the written client agreement is so, so important.
Absolutely. The information that you brought forward today just on disclaimers alone, disclaimers everywhere. Have your contracts, have these, have your contracts in place, have your documents in place. Disclaimers both verbally and in writing. Everywhere. Can I emphasize everywhere?
Yes, everywhere. It cannot hurt you, right? You might feel silly. You might feel like a broken record. You might feel like this is crazy. And it's really hard, as I was trying to emphasize, it's hard when philosophically sometimes in the holistic health world, you know, a lot of the reasons why many people believe so strongly in holistic health is because of traditional health system or has not served people to the fullest capacity or well. And some people in the holistic health world have strong feelings against traditional medicine, and that's totally understandable. And at the same time, we do have to legally be very careful not to discount the traditional medical advice and care that someone needs to receive from their own medical practitioner, because, as I mentioned, there are so many times when clients in the holistic health space are not disclosing everything to you as a holistic health practitioner. And they may not even be disclosing everything to their licensed medical practitioner either. So you have to protect yourself and the client by always referring them to the licensed medical practitioner as well. And Paula, just from your philosophy of like, we believe in the power of the and, like, we're here to all serve and all have our place to serve. So I guess I'm just addressing for those people who are like, but I don't want to tell them to talk to their doctor. I'm like, please, please, please do, just out of respect for yourself, but also respect for the client, that you may not know the full picture, even if they're claiming they're telling it to you. Yeah,
exactly. Thank you. But I do take issue with traditional medical practice because
that's fine.
AMA's been around for a little over 130 years. And so I think we're the traditional approach.
This is true.
And
yes, thank you.
I mean,
this is true. We're the original, but I guess
we're the OGs, right?
yes, that's right. I'm just using vernacular that a lot of people use, but you're correct.
Sure.
I completely agree with you.
They don't agree, but that's my perspective.
I agree with you. I love it. That's great.
Okay, next question. Can you give an example of common legal issue in our field and that's where it stops.
Sure.
Okay,
so a couple things that have come up. One is we talked about investigations by the state into your into your holistic health practice, either for violating medical laws that we talked about with the don't diagnose, treat, prevent, cure, heal part, or violating dietetics laws, saying that you're practicing dietetics without a license, or that you're engaging in one-on-one personalized nutrition services in a state where you're not supposed to do that according to your red or orange restrictive state laws. There's the area around these state investigations, which comes up from time to time. And then other things that come up around legal issues are often just client-based, where clients want a refund for your services. And if you don't have a written client agreement with a refund policy that spells out whether you give a full refund or a partial refund or no refunds, that's important. Clients will miss appointments and they'll then say, how do I make this up? And you may have a specific policy that they have to make it up by their next appointment, or they forfeit it, or you charge them for misappointment. You want that in your client agreement. Payment is obviously huge. What happens when a client doesn't make a payment, or they ghost you, as we say, or they do a chargeback, or how does that work? So you want to spell that out in your client agreement. But for most practitioners, things come up around investigations, around state laws, also just around clients and client disputes, which cause a lot of stress because it impacts your income. And then the third area we touched on is around the intellectual property, right? People taking your work, swiping your website content that we discussed, swiping your program content, using it without your permission, and you want to make sure you have legal language to fall back on. So those are the three, I think, big areas that come up often.
Huge. Copycats do steal your content. It does happen. It has happened to me early in my practice. And initially I thought, well, I guess that's a compliment, but
it's not fun.
So,
and when you put your blood, sweat, and tears into that content.
Exactly.
Yes. Heartbreaking.
Exactly. But, fortunately for me, in the few situations where that came up, it was a phone call, and it's like, are you aware of how much time I put into that? Are you aware that this was my work that you just lifted and anyway, so it was easily changed, but there came my documents, there came my disclaimers, there came my all of it. So
wonderful.
Okay, So I'm seeing if there's any other questions here. Excuse me.
Sure.
I think that we can wrap it up here pretty quick. I just really encourage you to follow Lisa. Her podcast, Legally Covered, is fantastic, and she keeps emphasizing they're 20-minute podcasts. So this is like get a pack of information in a short amount of time, and the rest of the services that you offer are just beautiful, Lisa. Thank you.
Thank
And
you.
one other thing is like your DIY legal documents color coded. I love it. Deanna Minnick is going to really approve of that too.
I know. I just saw her recently at a conference, actually. I do, when I was talking about the colors of the documents, they're aligned with the chakras, as I explained, of course, but all of those are available as do-it-yourself legal templates that people can download and fill out and just use immediately. And that was designed to make it easy for people. They're designed for holistic health practitioners. They have extra long medical disclaimers and all the things that we talked about today. So thank you for mentioning them. I helped so many people get legal documents in place in a way that makes it that easy and fun to have color in their legal documents, for sure.
Exactly. Just one piece of feedback here with a Quebec, Vermont question. Yeah. Amy says, thank you so much for answering this question so well. I know it was a little complex, but I'm so happy to have the ability to connect with Lisa and receive comprehensive information. Very clear. I appreciate it. Right.
Thank you. Thank you, Amy, for that nice feedback and for asking the question. And I hope it was helpful to everyone. So thank you for that.
Yeah. The applause is coming in. I wish you could hear it. I just wanted to share a little bit of it, right?
Thank you. And thank you, Paula, so much for caring so much. Like, to you, I love that you help people to understand the legal part of their business and invited me back to do this second webinar. And it's so important and so easy. These are easy legal steps to put in place to help you stay out of legal stress and financial stress, and doing things on the front end and being prepared on the front end. It's just like healthcare, right? Like, you drink your water and eat your leafy greens, and you protect yourself legally on the front end to diffuse situations on the back end. So thank you so much for inviting me and for having me back.
Absolutely. We're healers in business, and we got to take care of ourselves in business, and that's where you got us covered. Legally Covered with Lisa. Love it.
Oh, thank you. Right. Thank you so much.
Bet. I have a few closing words, everybody. I want to remind you that this webinar was recorded and it'll be available on the Hawthorn website under archived webinars in just a few days. And just to say, it's a treasure trove in there of resources, of information. Check us out. There'll be a survey to fill out right after the webinar ends, and it always helps to have your feedback or any comments you have about this presentation, any series that we've offered, and I do really appreciate you taking the time. I want to let you know that our next webinar will be July 2nd when we host Dr. Jeffrey Moss, and he's going to be presenting on Alzheimer's, insulin resistance, and inflammation. A huge topic that we are all facing and experiencing either personally or in our clients. So that'd be a good one. And our next All About Alumni is on Wednesday, July 3rd at 12 noon Pacific time. And we'll have Missy Beavers presenting. She's a Master of Science in Traditional Nutrition grad. She's going to be talking about what she's been doing post-grad, what all her activities are and the exciting things she's up to. And again, we just had so many previous terrific grad interview presentations. Check out the archives. And with that, I think we can conclude today's presentation. I want to say how grateful I am for James Bernardinelli, who engineers these webinars. Thank you, James. And thank you again, Lisa. It was just a fabulous presentation. And I want to thank everybody for sharing this educational experience with us together. I want to wish you all the best of health, and I look forward to learning more together at Hawthorn University's webinars and All About Alumni series. And until then, I'm going to continue to practicing legally, as well as happiness, compassion, and kindness, because you know what? We practice grows stronger. So I hope you'll join me in all of this too. Till then, till we meet again, take good care, everybody.